For those of you who need translation, you can find appropriate equipment, and we can start. The name of our roundtable, Legal Systems of the World, Dangers and Opportunities of Replicating Legal Institutions. This issue is highly important for lawyers in general, also for judges in particular. And any country of the world is taking the elements of other legal systems to a certain extent. Sometimes this experience is successful, and sometimes it's not successful at all. Some innovations work in the national systems, some don't, and Russia is no exception. And we had said experience of implementation of Anglo-Saxon institution of trust on the one hand. On the other hand, we had comparative titles regarding land ownership that are typical for Anglo-Saxon system worked in our country because of the land code and the motives why certain institutions work in certain countries or don't work. Those could be political motives, special desire to implement something. That could be psychology of people who like or don't like certain institution, and they accept it or they don't accept some innovation. Or it could be just something that happened by chance. What's more important? What's more significant for the reception of foreign institutes? And would like to talk about it. And first, I would like to give the floor to Mr. Rajendra Malhotra, the Chief Justice of the Supreme Court of India.
I am Rajendra Malhotra, Chief Justice of India. Well, Indian legal system, although people title it as a common law system, as a matter of fact, is something of common law system as well as civil law system. Reason being, large number of Indian laws are codified by Indian Parliament and the state provincial legislatures. So far as law of torts, contract, penal code, criminal procedure code, they are being influenced by common law. But as regards constitutional provisions, it's sort of a where the matter relates to enforcement of rights, like we have Article 14 in the Indian Constitution, which has equality clause borrowed from Ireland and equal protection clause borrowed from America. So it's a classic case. India is a classic case, as a matter of fact, of convergence of two legal systems, civil law as well as common law system. Our country is a very strong country following rule of law, and courts, particularly superior courts, that is Supreme Court of India, and the provincial high courts, they are leaving no stone unturned in ensuring that rule of law is maintained by all state agencies. So wherever question of enforcement of rule of law arises, Indian courts have worked very strongly and have passed strong orders against the government. Look, there are certain things we have, like arbitration law, which is in conformity with international standards and laws, but its interpretation has been little different so far as enforcement of foreign awards is concerned. But that's being corrected. A recent decision has been Sri Lal Mahal Industries, where the court have laid down a narrowed principle of public policy insofar as enforcement of foreign awards are concerned. So far as law is concerned, India is a multicultural nation. I'll give you an example. We have a state, Goa, which was earlier ruled by Portugal. Now that state continues to have a large number of laws which are influenced by Portugal, and they have uniform civil code which is not applicable to other parts of the country. Then we have personal laws which differ from religion to religion, like so far as Muslim personal law is concerned, they have their own laws, and Hindus, which form majority, they have their own laws. But Article 44 of Constitution of India has laid down as a directive to form uniform civil code. But of course, efforts have been made for last 6 decades, but there is no uniform civil code, and different parts of the country continue to have respect to different religion, different culture, and different historical backgrounds, and laws continue to govern differently to different communities, but constitutional protection is available to all. That is the biggest guarantee to Indian citizen. Thank you.
Спасибо, господин.
Thank you. Thank you, Mr. Chief Justice. May I ask a question, whether there is a strong difference in regulations from province to province, from state to state in India, and in Russia, regarding civil law, there isn't much difference. But what is the influence of special features of different states on the general situation with the law development in India?
So far as federal laws are concerned, they are applicable across the board. All states, all provinces are governed by federal laws. So far as land laws, law and order, land acquisition, now there are certain subjects which are guided by local conditions, and every provincial state legislature has authority to enact own laws for governing citizens in its own state. So far as revenue laws are concerned, that is concerning land, building, civic amenities, they all are governed by special laws having regard to special features of every state. Like there are certain provisions with regard to land resumption, that again is governed by local laws, but by and large the guidance is borrowed from Constitution of India, which is guiding feature for all provincial states. The Constitution of India has basically 3 lists: Union list, which of course empowers Parliament of India to enact federal laws. Then there is a state list. Now subjects covered by state list, like excise laws, certain local taxes, municipal taxes, now they are regulated by state laws which are enacted by provincial state legislatures. But the peculiar feature is there is a concurrent list in the Constitution which has about 60 subjects on which federal government can enact the law, and so also the state legislature. If a state legislature enacts the law, but later on federal law steps in and enacts the law on the same subject, then federal law governs. But peculiarity is about local taxation and land revenue cases, land revenue laws. They are governed by local laws, and they keep in view local features, land holdings, the financial means of the people within the state, and accordingly enact the laws. Thank you.
Спасибо.
Thank you. And now I would like to give the floor to Mr. Markus Metz, the chairman of the Federal Administrative Court of Switzerland.
Thank you, Mr. Chairman. Ladies and gentlemen, I would like to talk on the features of the national legal system and the globalization we are currently going into. The national legal system in Switzerland depends on its, largely on its history. And that's why I would like to turn back a little bit into history. Switzerland has emerged from pure farmers' land into a highly economic society. Switzerland had no kings, never, and that influenced its history to a large extent. We have elaborated a labor market efficiency, while employees benefit from generous social benefits and strong protection against health damages and such. According to Swiss law, it is relatively easy for both employer and the employee to terminate the employment. This prevents employers from refraining from employing people out of risk considerations. So we have a highly liberal labor market. We have academic practicability. The Swiss public law guarantees a high standard of public education. Private education is not supported by government. We have a strong, and that is very important, a strong intellectual property protection to boost innovation. We have efficient governance. Swiss public institutions are among the most effective and transparent in the world. Separation of powers, strong democratic power, and high accountability make the public sector both efficient and attractive to work in for highly motivated and conscientious personnel. We have a very simple private law, codified civil law written in simple language, makes it easy for even non-lawyers to find answers to their legal questions. We have a very flexible corporate governance. The law of companies allows the local implementation of various systems from all over the world. We have, on the other hand, a protectionism in markets, high entry barriers in many industries, as well as protectionism in agriculture sector damage the long-term competitiveness of Switzerland. And above all, we have a direct democracy. It is currently subject to debate if the direct democracy in Switzerland, beside its positive effects for democratic principles and popular trust in the government, may also have negative effects on the rule of law, the certainty of law, human rights, and subsequently the performance of Switzerland in a globalized world. We have now current discussions of even terminating the European Human Rights Convention, which would be, to my opinion, to the detriment of Switzerland. But nevertheless, you see, we are focusing on human rights as well. And it's amazing if we talk about globalization, we are mainly talking about the economic issues. We are rarely touching the human rights issues, which are very different in different countries. So if we talk about globalization and harmonization, it refers mainly to economic values and not to other institutions. Thank you.
Большое спасибо.
Thank you so much. And if I may, I would like to ask you one question. It's no big secret that Anglo-Saxon institutions, well, including trust, well, they're supposed to be the most convenient to manage financial assets and also attract funds. And a number of European countries, continental law countries such as Liechtenstein, tried to implement similar institutions, similar to trust. What is the position of Switzerland regarding implementation of such institutions in their national law, such as trust?
Switzerland does not know the concept of trusts. We know the concept of a foundation, which is very similar to trust, which is a capital on its own, which is very similar to trust. So we don't see the necessity of introducing the Anglo-Saxon model of trusts.
Спасибо.
Thank you. The next participant of our discussion, Ms. Fernanda Galicia Noriega, judge from the Court of São Paulo, Brazil.
It's a pleasure to be here. I'm a judge in Brazil, in São Paulo. It's been 17 years. I worked for long in a civil court, and we faced some problems regarding parties, of international parties. And because of that, we thought about how it would be to create a hybrid court mixing common law and civil law features. Would it be possible? I don't know if I may, I had a presentation. I said the presentation. I don't know if it would be possible to put the presentation for you to follow. I think it would be, yeah, that's it. Thank you
It's
so
possible, please.
Spasiba. Regarding globalization, it's the main issue. We think about the necessity of an effective and reliable international justice. How it would be this construction of a hybrid court, which characteristics of common law and civil law should be considered? How it would be the coexistence of this hybrid court with the national legal system. Brazil is a civil law system. We have the codes. The codes are federal, applied to the whole country. Brazil is like Russia, a big country. As you know, I guess many people are following Brazil now because of the World Cup. And some people asked me at the beginning, why am I doing here if there is the World Cup there? Well, if you saw the game yesterday, I better be here. There is one of the slides that there is a picture of the, I don't know if you could put it further. There is a picture of the court in Brazil, and I wrote, are the courts the same? They look the same everywhere. If you go to a court in Brazil, if you go to a court in England, if you go to a court in India, in Switzerland, they pretty much look the same. But what can we expect from inside the court? So if you are not from Brazil and you have to go to a court in Brazil, what are you going to expect? How are you going to... Thank you so much. Thanks a lot. So this is the picture. This is the Palace of Justice in São Paulo. It's a very beautiful building. But again, what there is inside this very beautiful building? Is it a common law court, a civil law court? If you look from outside, you don't know. Would it be possible to have a hybrid court mixing both systems? And again, in the construction, what we would have to consider for the construction of this hybrid court. And the question, are the legal systems turning hybrid along the years? If we see common law systems, they have a lot of statutes. Things are changing during the years. We have now in Brazil something that is pretty new, which is binding decisions from the Supreme Court. We call them súmulas vinculantes. It would be something like, if the case has been decided before, the court has to follow that decision. This is pretty much like common law. So it's something new. So are we having a hybrid system already and we just didn't figure out that it's happening? So this is the main question, what to expect. Perspectives for the future. The hybrid court in the national level could lead to a model of hybrid court for the development of a unique global legal system. Common law and civil law systems, do they need to change? Parties of different legal backgrounds. The claim for a fair justice system. Is it fair that you have common law, civil law, and that you have international parties litigating? And one point is regarding arbitration and hybrid court. I remember that I was talking to my husband. My husband worked for IBM for more than 20 years, so computers, and he doesn't understand very well legal stuff. And when I was talking to him about this concern about this hybrid court, and he asked me, I don't understand. If it's a company from the United States that comes to Brazil for business, they are supposed to have a law firm in Brazil. And I thought, it's not that simple. Of course, you can hire some lawyer in Brazil who knows the Brazilian laws, but wouldn't it be better if you would be able to apply part of your system in another country? Like in the States, for instance, they have interrogation, depositions, many things that happen before going to court. In Brazil, if you want to hear some witnesses, the thing that you have to do is 5 days before the hearing, you have to give the name of those people in order to the other party to know who they are. But this is the only thing. You don't know what is going to be produced in court. So is it fair for someone from the United States or some other country that has common law to go to a court, do international business, and just don't know what's going to happen, what to expect? It's kind of a surprise. I faced a problem working in a civil court more than once. I had cases that people had an international contract and they went to court even though the contract had an article foreseeing arbitration. And we have in our civil procedural code something that says, an article that says that if the parties decided to choose arbitration, they are not allowed to go to court before they finish the arbitration process. But what is happening recently in Brazil is that people, when they have some urgent measure, they don't go to arbitration. They have the arbitration clause, but they just ignore the arbitration clause and they go to the court. They go to the judiciary. And I have a sentence, actually used it many times. I had a model of the sentence that I used it saying that, no, the court is not accepting this because you have a contract and you have to go to arbitration. And arbitration also foresees the possibility of urgent measures with arbitration. So this arbitration problem was the main thing that made me think about the creation of this hybrid court. We will try to develop something in Brazil. We have in the state São Paulo Court of Justice. We have some special courts, environmental court, at the Court of Appeal. And we are thinking about trying to develop something, at least with some guarantees like having a judge who knows both systems. trying to make it better for international parties to have more fair justice in Brazil. So this is a project that we are working on. Thank you so much.
Большое спасибо.
Thank you very much. It's an interesting, it's an exciting idea to combine two legal systems within the same court. To use civil law and common law within the same court. Even though maybe I did not quite understand what you were talking about, but our businessmen, they pretty often use common law, English law, and it might make sense to create a group of specially trained judges who could apply substantive English law to some specific cases, just as an experiment, and then we could better understand why Russian businessmen go for English law. Is it because they fancy the law, or because they want to have their case heard in England? And it doesn't make any difference what kind of law will be chosen. The big thing is to go to England. It will be, like a litmus test, which will help us better evaluate the performance of the legal system. But it's just an idea, it's just a hypothesis. I don't know whether it will be translated into real life or not. Now I'd like to give the floor to Mr. Joseph Brand, who is a partner with Patton Boggs.
Будем потом.
Will there be any more questions? There will, later on.
Good morning. Our subject is successes, opportunities, and dangers of replicating legal institutions, what we in the literature call legal transplants. I would like to talk about three of these. One I would recommend to be adopted by countries, one I would recommend to be adopted by the United States, and one which comes from the United States, I would recommend that you not adopt. Now, to put this into perspective, let me pose two questions, and I think that both questions have the same answer. The first question is, why, with very few exceptions, Switzerland being a notable one, has every civil law country at some point in its history become authoritarian? And why has no common law country in its history ever become authoritarian? I think the answer to both questions comes from the strong courts that we have in the common law system and stare decisis. In the United States, 14 years after the enactment of our Constitution, 14 years after our country came into existence, our Supreme Court arrogated to itself, in a case called Marbury against Madison, the right to rule on legislative acts, to determine whether the legislative acts were or were not constitutional. This had never happened before in the history of law. And it wasn't something that the Constitution gave these courts. It wasn't something the executive or the legislature gave the courts. The court decided on its own initiative that it had the right to review legislative enactments. And our Supreme Court today, many, many years after 1803, when Marbury against Madison was decided, is a very, very active court. And if you look at the decisions it takes each year, you would find two things to be outstanding. Number one, as our judge from Brazil has said, the common law has changed a great deal. Our Supreme Court last year decided less than 100 cases. In most years, it would decide 300. None of those are common law issues. They're all issues of statutes. So we've morphed, in that respect, more to the common law, or to the civil law. But the reason, Mr. Chairman, that your people here like to use the English legal system is not so much because of the courts, it's because of the doctrine of stare decisis, which means, on the same issue, a future judge is bound by the decision of a prior judge within the same legal system. So if you have a fact pattern here in Russia, and you want to find out what the answer would be if you litigated that in the United States or in perhaps even in India, but certainly in England, you would look at what the other cases had said, and then you would know what this case is going to be. So that promotes certainty in commercial transactions, which every lawyer and every businessman wants. Now, that's one transplant I would suggest that countries ought to take a hard look at. Binding precedent, what you call stare decisis, active courts that can review legislative enactments to see if they're constitutional or not. The one I would not recommend countries adopt, which came at the same time at the United States first Congress was enacted in 1789, is the law we call the Alien Tort Statute, which provides jurisdictions to the federal courts of the United States for a foreigner injured by a human rights violation in his or her own country. The first case that was decided under this statute, which was enacted in 1789, in fact was not decided until 1980, and that was the subject of the lawsuit was a Paraguayan who had been tortured by a Paraguayan, and the next of kin of the deceased Paraguayan brought the case in the United States under the Alien Tort Statute. And this has fomented a great deal of litigation in the United States, to the point that a former legal advisor for the State Department said that the United States is now the civil law court for the world, not the criminal law court, but the civil law court for the world. And I don't think that's something that we should be doing. I think that's an exercise of extraterritorial jurisdiction that is not proper. The one I would recommend that the United States adopt, and other countries might well want to consider this also, is an institution in England called the Equality and Human Rights Commission. And it assists both institutions in England and citizens in England to observe and enforce human rights laws. We have no such institution in the United States. We have 50 states. Each has some kind of sovereignty. Some states claim more sovereignty than others. Under the Vienna Convention, if an accused has a right to consular authority of his or her own country, we have states in the United States that do not recognize that. The state of Texas has executed 2 prisoners, neither one of whom had the right of consular review by their own country. And those countries obviously protested that to the United States, but we have no institution that regulates that. So that's why I would suggest that the Equality and Human Rights Commission of the UK would be one that the United States should take a hard look at. Thank you, Mr. Chairman.
Thank you very much. Somebody asked me when it was time to ask questions. We have one last presenter. I'd like to give him the floor. And after he's done, we'll have time for questions and answers about what has been said and about what has not been said, has not been mentioned. Now I'd like to give the floor to Vladimir Churov, who is chairman of our electoral commission. Thank you, Mr. Chairman. The electoral system is a unique legal and administrative system. The modern Russian electoral system was created in the mid-90s. A lot of elements were borrowed and replicated from Western Europe. Above all, what was borrowed came from unitary France and federative Germany. However, over the past 20 years, our electoral system has developed dramatically and moved closer to well-developed electoral systems like South Korean, Brazilian, and Indian systems. Even though our Western European partners have not upgraded their electoral systems, which in Germany resulted in the absence of legal observation system on poll stations, and in a situation where the most recent Bundestag elections, more than 300 results were revised and cancelled. It is an unimaginative figure for Brazil or Russia. International legal cooperation institutes in the electoral system, like the World Assembly of Electoral Bodies and European Organization of Electoral Bodies, OSCE and others, led to unification of some founding principles behind elections in democratic countries, except for probably the United States, where the electoral system is absent, which actually makes the results of elections in that democratic state debatable at the outset. There is one critical problem I would like to discuss with you. The electoral system cannot operate unless it cooperates closely with the judicial system. With a system of trial courts, which hear election disputes, and without cooperation with the constitutional courts, when critical electoral legislative issues are decided.
And I can tell you that I know fairly well about our Brazilian colleagues, and the words about the single Supreme Court, as was pronounced by our colleague, means that this is one of the highest courts, or rather it is formed with some delegated authority from other superior courts. And I think that this is the way that is taken by our Brazilian colleagues. But there is an international court on whose some unlawful actions about electoral law should be really discussed further. Together with Professor Abzeev, a couple of years ago, we warned about the risks of the electoral practices of the European Court for Human Rights. Unfortunately, the practice of recent years confirmed our concerns. And the attempts of the ECHR to interfere into the fundamentals of a democratic state, I think, became commonplace. In the electoral law, the decisions and judgments made by the European Court for Human Rights in relation to Russia and the UK, by making those two countries to authorize the convicts to participate in elections, is a direct intrusion into the authority of the Russian Constitutional Court. That is why neither Russia nor the UK have implemented this judgment of the ECHR. One of the fresh cases accepted for review by the European Court for Human Rights, and we received some questions around this case. Please provide clarifications about how members of the electoral commissions of the district, circuit and territorial commissions were nominated, including members with voting rights and without such. Which parties do they represent, and how many members were related to parties but for the single Russia, Unified Russia Party, in percent and in absolute numbers. This is the example when this court is trying to directly interfere into the affairs of a state by trying to replace, to substitute some common courts. Another point of concern that we observe in the developments of the court systems across the world is a politicized approach to assessing the results of both elections and procedures. Such an authoritative body as the Bureau for Democratic Institutions and Human Rights of the OSCE of late is too politicized in its assessments. Well, some of the statements by politicians, top politicians in some countries are really something else. 10 days before elections should be taking place, such elections are beforehand declared legal and justified, but others do not. I should say that probably one of the best elections I ever saw was the elections in South Ossetia, a small state, but the elections were organized in full compliance with all the procedures. I won't name the countries where you will see many violations during elections and deviations from the established practice and procedures. To give you another example of, I'll say, double or even triple standards. For many years in Russia, we have observed a discussion with the involvement of international experts about the Swiss practice of direct democracy, where many questions are decided through regional and federal referenda. But for some reasons, such advice about using direct democracy, about the advantages of using direct democracy, somehow disappeared from the agenda. When do you think it happened? It happened when the referendum was held in the Crimea. Thank you very much.
Вам. Но мне бы хотелось перед переходом.
Thank you, but perhaps I should ask a question before giving the floor to any speakers. Perhaps that's a question that I would like to address to all the speakers. Do you see any differences between borrowing public and private law, between borrowing something from the practice of private law and public law? So what could be borrowed, and are there any differences in this practice of transplanting the procedures from the two systems of law? What is easy to be done and what is not? Are there any those who would like to say something? Perhaps I should go first. To put it simply, I think it is simpler to transplant public norms and procedures, but it is more dangerous and riskier from the political point of view. Anyone else? No? Don't see anyone else willing. Perhaps we would have some Q&A with the audience, please. Do we have a microphone? We need a microphone, please. I hope you can hear me. Yes, we do hear you. Let me introduce myself. I'm professor of the law school of the St. Petersburg State University, and I have a question to Ms. Norega. You know, I simply misunderstood why this contact with arbitration led you to the idea of having some hybrid mixed courts. Would the arbitration not be popular in your country, or would it mean that if you have some arbitration clause, you can simply go to a common court for litigation?
Actually, arbitration is becoming popular nowadays in Brazil. But what I realize is not, of course, only the arbitration fact that made me think about this hybrid court, but arbitration problems, I should say, were the things that made me think also about this hybrid court, because when you decide to have an arbitration clause, it is supposed for the parties to solve the problem through arbitration. But what I realized was that maybe it's because of Brazilian culture, we are not used to arbitration. It's a new thing for us in Brazil. It seems to me that people somehow don't trust. And if something, if a big problem happens and they want it to be solved quickly, they decide to go to the court, to the judiciary, to have an urgent measure, not the case solved, but an urgent measure that the judge decides at the same day and says something. It happened to me sometimes, and it made me think about it. But it's not the main point, the main issue that made me think about these hybrid courts. Just the hybrid court would be something for international parties to have a more trustable justice regarding international problems. This would be the main point. The arbitration was just one thing that happened in some cases that called my attention, but it's not the main point. I don't know if I made myself clear.
Спасибо. Вы удовлетворены?
Well, thank you very much. Are you satisfied with the answer? Are you happy? Well, the road to truth is always a lengthy one. And do we have any other questions to the speakers? Do we have any other questions from the audience, please?
Yes, I would like to raise a quite interesting issue. Before a speaker has talked about the electoral system and parties and judges. And we have a quite different system in Switzerland as to parties and judges. I just read in a newspaper or in an article that in Russia, for example, judges may not be members of a political party. In Switzerland, in the opposite, judges cannot become judges if they are not member of a political party. So to join a court, a federal court, or a state court, or even a court at the community level, you have to be a member of a political party. And the bench or the court, the mixture of judges is reflected in the parliament. So we have the same political proportion in political parties in parliament as well as in courts. And to our tradition, this does not influence any the independence of a judge. Once a judge is elected, then he is entirely independent from his party who voted for him.
Спасибо.
Thank you. There was a question. Perhaps I can carry it myself to the ones who would like to ask a question. Unfortunately, the interpreters cannot hear it. The microphone is off. Unfortunately, the microphone is not working. What is this interference into the independence by the Russian Federation in the fact that the European Court for Human Rights obliged our country to let the convicts participate in elections? So what is this violation, you think? I should probably clarify. I'm a self-made lawyer. I was not talking about convicts. I was talking about people who are in detention for any possible crimes and fraud with imprisonment. But perhaps I can give you two examples of the dangers and threats of having this partisan approach to composing courts. In 2012, in the US, during elections, the work of the Federal Election Committee was almost paralyzed, although it was really very limited in its actions. But the fact was that half of the Republican Party was in favor always or against, and the half of the Democratic Party was likewise always either in favor or against. And also in 2012 in Ukraine, some of the district election committees were paralyzed by the same reason. Or those election committees were established on the partisan principle, so half of the members were in favor and half were against. So many of the election results were later recognized null and void. That's a comment to my Swiss colleague. But answering your question, the prohibition to people held in detention and the decision of the court is established by Part 3, Article 32 of the Constitution of the Russian Federation, the contents of which, before being discussed nationwide, was reviewed by the Venice Commission and was recognized as meeting the European standards. Very well. Do we have any other questions? Dear participants in the conference and dear speakers, I have a question. Can we claim, in the context of our subject to be discussed, that the institution of law has been firmly established in all the three systems, which is not always the case in some other systems? What is your question? Who do you address this question to? I think to all the speakers. I don't know who would like to answer it, but I think that in most of the cases we're talking about some differences in interpreting the terms. I think if you're talking about the institution of law, then it may be perceived in a different way in different countries. I think it's a very difficult question to answer. I don't know if somebody would like to really comment on that. I think that borrowing from foreign law, I'm not talking about international law, I think this borrowing is a positive thing. It is better to learn from somebody else's errors in practice than from your own ones. And some of the countries borrowed whole codes from other countries. Take Turkey, for example. But this positive phenomenon still has some painful aspects. And we mentioned some of them. We're talking about exterritorial application of law. And the other aspect is basically something that is called by some expansion of the Anglo-Saxon common law into the continental civil law countries. And in Europe we had a number of movements and really criticisms about this borrowing. So I have this question to Professor Metz, and it's an open secret actually that we actually borrowed a lot from the Swiss law. For example, our civil code for international law, even as amended, is based on the Swiss international private law. But I wonder to what extent this Swiss international law is still influenced by the Anglo-Saxon law. Can we claim that we observe this, something that is happening in France, something that is really heavily opposed to, or can we still consider that the codes that were established 100 years ago by Huber are still pure and can be applied as is?
Yes, the borrowing or reception of law by other countries, it's quite common. And Turkey, in fact, has recepted the civil code to a large extent of Switzerland. On the other hand, the influence on Swiss law from international law is not very large. We still stick to the civil law concept, and on the other hand, we have a lot of expansion in international supranational law, not as a origin Swiss law, but influenced by our multinational and bilateral treaties we are entered. So to answer your question, we stick still to the civil law concept, and the common law concept has not a great impact in Switzerland.
Can I respond? Yes. Of late, borrowing of law by civil law system from common law and common law system has been quite frequent. I'll give you a few examples. Bankruptcy laws. Common law favors reorganization of debtors and debtor companies, while civil law actually favors liquidation. Now, of late, like France and the few African countries, they have adopted common law practice of giving an opportunity to debtor to reorganize before it is asked to liquidate. Another example I'll give, which is really wonderful, about English court following civil law. A testator executed a will, and that is White versus Jones, and after some time, he asked the solicitor to amend few clauses to give benefits to few other dependents. But before solicitor could amend the will, the testator died. And then the dependents who were to get benefit, that they sued solicitor for damages, and English court borrowed civil law concept and made the solicitor liable. So, and there are cases and cases. Recently, White Industries case following bits. So these days, the courts have been following, civil law countries have been following common law principles and practices, and common law countries have been following civil law. Recently, I decided at the Supreme Court where a legislature was in issue, water dispute between two provincial states. The question was whether one of the states had jurisdiction to enact the law when the matter has been finally decided by the highest court of the country. One of the states, Kerala, they followed this Wheeling Bridge case, applied precautionary principle, and annulled Supreme Court judgment. Now, the constitutionality of that provision was an issue before the Indian Supreme Court, and we set it aside. We said that no, the minority judgment in Wheeling Bridge was more applicable to the Indian legal system than the majority principle. So, of late, both the systems have been following from each other. Thank you.
Спасибо. Вопросы еще есть?
Антон Александрович, можно маленькую реплику?
If I may, I would like Professor Makovsky. I would like your microphone doesn't work. Well, anyone with a microphone. Well, there is a button over there. You have to push it. No? Yes, the red button, but no, it doesn't work. Nobody hears you. Well, now you're talking. Well, and the bankruptcy legislation is a very good example to discuss influence of foreign law, because in the Soviet Union we had no bankruptcy legislation, and in Russia we had to start it from scratch, influenced by foreign law, and it was foreign influence. Well, maybe our teachers were not that great, maybe the students were not that good, but we have the fact that in the course of 15 years we have 3 bankruptcy laws, one after another. And now we have hundreds of amendments to the 3rd law on bankruptcy. So in replication of foreign experience, something might be wrong. Okay, more questions? Yes, please. Thank you. Sergei Pepelayev, managing partner of Pepelayev Group. Replication of legal institutions. Well, it's not just. It doesn't just depend on the recipient country, but also Anglo-Saxon law is quite popular in Russia, also because here we have lots of companies from the US, from England, and they promote English law here or American law here, but this is a Russian legal forum here, and I believe that here we could discuss some Russian values that we can promote or we can export. And my question is to maybe you, Mr. Ivanov, you, Joseph, and what is valuable in Russian law, public law, private law? What do you see? What can you recommend to be applied in other countries? And what public and government institutes could be used to promote our national values in other countries? Well, it's a very good question. I'm going to mention what I thought about immediately. It goes without saying that in our civil code we have this systemic regulation of the intellectual property rights, exclusive rights, and this is maybe the very first example in international practice when we have a codified and along with the general part, and we have all the details regarding the provisions of intellectual property rights. In most of the countries, intellectual property laws are separate laws that are passed on the basis of international conventions, and I believe so. This is something we can promote and we can suggest to others. So it's all codified. It's in our civil code. You have any desire? Yes. Well, it so happened that I read all the texts by Bob Arikin when I was a child. That's regarding bankruptcy. And I believe that in Russia, before the socialist revolution, some commercial law issues, including bankruptcy issues, were reflected in detail. There are 19 volumes of the laws of Russian Empire and plus 19 volumes of comments, and we can find a lot of useful information. And regarding our law and practice, so what is our law of application of information technologies and electronic voting. And OSCE, at our initiative, created a special department on outlining international standards and best practices regarding electronic vote. A number of countries used our electronic vote system. Secondly, this is the legislation and practice of having the voters register, and now the accuracy rate is 0.003%, and there is a verification procedure, and also that system was replicated by a number of countries, and it's one of the best practices in the world. More questions? Yes, please. Professor Yershov, Russian Academy of Justice. In the documents, in the literature, and also today, people used the term standards. I would like to ask all the speakers, well, could we use the term standards? Is it right? What is the legal nature of standards as such? Well, thank you for your questions. I just dealt with that issue regarding international standards of elections, so-called standards. As of today, there are no international standards of elections. From the legal point of view, you can see ICO documents regarding the standards, and only ICO document and accepted at the national level could be called the standards. Everything else is just pure talking. Well, you're tough, but by standards, everybody understands different kinds of phenomena. And when we discuss the standards as mandatory rules and that everybody should follow, in this case, we don't have any international standards or international institutions. But if we look at standards as best practices, it goes without saying that this term can exist. A number of countries set an example of the most efficient regulations and management of certain fields. And these are certain standards that we could use as our targets, our goals, but they're not mandatory to follow. These standards are not mandatory. These could be treated as recommendations that you can study, you can disseminate, you can promote, but not more than that.
It may be interesting to note, so far as Indian standard is concerned, a free and fair election is the goal and the standard set in the Constitution. And you'll be surprised to know, recently, only 3 weeks back, our country having population of 1.28 billion, eligible voters being 830 million, 660 million voters having cast their votes. The elections were held through EVMs, that electronic voter machines, and within 24 hours, 542 seats of parliament results were declared, and we have, of course, a procedure of challenging the election before a superior court, that is High Court of this state where constituency is located, and from there an appeal comes to the Supreme Court. But about fairness of the election, there is no challenge and no EVM has failed. With such a mammoth exercise, the election has been successful and transition of power had been absolutely smooth. The standard is free and fair election. Thank you.
Спасибо. С этой точки зрения...
Thank you. Well, from this point of view, you know that President Obama, prior to the elections in Ukraine, 10 days before the elections, called that free and fair. If we look at free and fair standards set by President Obama, it's going to be a very peculiar situation. Yes, that's clear. Veronica Hor, a lawyer from Berlin. Mr. Churov, you said that there are no international standards for elections, but there are some main principles, like, for example, the voter could have physical access to the voting station, not 200 kilometers away. It must be anonymous and must be a secret ballot. The principles are there. The standards are not there. Principles, for example, in the German agency didn't allow us to open some extra ballot stations for citizens of the Russian Federation, and the bus from the Consulate General in Berlin had to go 200 kilometers plus to organize the vote. But the same exists for German citizens in Russia. For them also, we don't have a special station for them in Novosibirsk. Unfortunately, this is the case. More and more German citizens move to Russia, and they settle in Russia, and they have to vote. But your embassy, I'm ready to help you. Your embassy didn't ask about assistance. A lot of countries ask for our assistance, and we organize special equipment at the... I don't think that Germany needs your assistance in this respect. Well, that's wonderful. Let's not make our round table discussion about election legislation. Are there any questions? Are there any additional questions? The speakers, no more questions. In this case, as the moderator, I'm going to say a couple of words just to sum it up. In the beginning of our work today, it's not by chance that I mentioned the trusts and regulating appropriate relations, and I asked my question to the representative of the Swiss judicial system, because this part of Anglo-Saxon law is the most complicated to be adapted in the countries of continental law, and it hasn't been adapted. Well, practically nowhere it was adapted. There are some countries that accept Anglo-Saxon law or don't accept Anglo-Saxon law, but to get trust adapted as part of continental legal system, this is a very complicated phenomenon, and that's why Liechtenstein and Switzerland decided to use their so-called foundations that are managed by certain persons in order to substitute for trust. And it seems to me that this is the right approach for the Russian Federation, because we have this real clear need of managing somebody else's property, and the contracts that we have the same. There is the same need in the inheritance law, because in our inheritance law, unfortunately, it's impossible impossible to leave the inheritance with the conditions, and it's impossible to set the conditions, which is also creating complaints on part of business community. And we have to solve those problems, but not by replicating trust here, but by way of creation the family foundations that could be managed by certain persons. And in general, it's the right approach. And also, it's interesting that our land legislation still is not based on continental traditional, but on the titles, leasing titles that are so similar to titles existing in Anglo-Saxon land law. And this phenomenon is working here. Trusts don't work here, and these systems, they're quite well, they feel quite well here. And now we're going to have the new version of the civil code, and a lot of lawyers are against substituting it. They would like to leave those titles, leasing titles, in force. And replication, it's a very complicated procedure. It's very controversial, and quite often subjective factors play much greater role than objective needs, because objective needs are there, but they could be satisfied using different legal means. And quite often replication can lead towards great, wonderful results if it's accepted by people and by the political system. If the political system doesn't accept certain institution, of course, even if it's accepted, it's not going to be functional and it's not going to be viable. And the lawyers have to make the right choices when they would like to replicate something, and the lawyers have to change them, get them adapted regarding national features of appropriate countries, and suggest the appropriate versions for the lawmakers, and such institutions are going to be successful for sure. And regarding replication and the law in general, I wouldn't have this chauvinistic approach, and I would say that the law is so flexibly liquid and is coming from one country to another country, and we cannot say that the majority of legal institutions are of national nature.
Each of them has borrowed at least something from a different country. So you can never say it is purely our institute and that institute or that system is somebody else's. You can never tell whether it's yours or not. And how many alien elements are there and how many our elements are there. Thank you. Well, it seems like we have an early finish.